we have a quorum. I'd like to introduce our new attorney for the board, Veronica Gonzalez-Zamora. Want to say anything?
Hi, everybody.
Okay.
That's about all I can say.
Is there a motion to approve the agenda? Is there a second?
Second.
All those in favor signify by saying aye.
Aye.
Any opposed, say nay. Motion carries. All right, has everyone had a chance to review the minutes of December 2nd? Does anyone need any more time? Seeing none, is there a motion to approve?
So moved.
Is there a second?
Second.
Okay, all those in favor signify by saying aye.
Aye.
Any opposed, say nay. Motion carries. Okay. Action 6, evidentiary hearing for sworn complainant 2022-001, Carl L. Peterson versus Commissioner Charlene Pasoki. I'm sorry, I probably said your last name wrong. Okay, so any pre-hearing motions from the board?
There, with regard to the motion to dismiss, I move that we deny it on the merits.
I second that.
Hey, any discussion?
The motion raises both procedural and substantive issues. I think it's untimely. That waives personal jurisdiction, but as far as subject matter jurisdiction can be raised at any time. I think it should be decided on merits and denied.
Okay. Any other discussion from any of the board members?
Mr. Chairman, are we allowed to actually address the motion for the board, or is the board going to act without hearing argument?
Mr. Candelaria, you've already submitted your comments on that. We all have it. We've all received it. So at this time, no, sir.
Okay, I would just like to note an objection. I think that not allowing the parties to address the motion is a violation of my client's due process rights, and we preserve that for appeal if needed.
What's the board? Let's get there and check with the other board members to see if they disagree, which would be fine.
I think that's just fine. Subject matter jurisdiction can be raised at any time, so
Okay.
take no issue with.
Okay. But Mr. Candelaria will allow you to address it only on this issue, no other issues. Go ahead, sir.
Thank you, Mr. Chairman. For purposes of expediting the issues before the board, we're going to go ahead and set aside the objection based on personal jurisdiction. While I disagree with complainant's arguments that the rules of this board require that defense to be pled at or before the preliminary hearing stage, I don't think that it's worth spending much time on in light of the case law that the complainant cites, which I do think is instructive on that question of personal jurisdiction. The issue of subject matter jurisdiction, however, is timely. It can be raised at any time, including for the first time on appeal. And here's the issue in a nutshell, Mr. Chairman, and members of the board. Ms. Allerid's $5,000 expenditure is one of three things. It's either a gift under the County Code of Ethics, it's either a contribution that is regulated by the code at 2-130H2, or as we contend, as the respondent contends, is an in-kind contribution that is not regulated by the County Code of Ethics, but rather regulated by the Campaign Practices Act, which limits in-kind contributions to $5,000 for a primary and $5,000 for a general election. So in this case, the complainant advances two theories. One, either Ms. Allerid's $5,000 expenditure was a gift, and thus implicating sections of the code 2-130D1 and 2-130D2, or it is a contribution that is regulated by 2-130H2. It cannot be both at the same time. The challenge, Your Honor, pardon me, old habits, Mr. Chairman, is that this court does not have subject matter jurisdiction to determine whether or not Ms. Alarid's expenditure is a gift. Now, why is that? Because the County Code of Ethics and County Code of Conduct very specifically states that a gift, or rather, let me say it this way, that a campaign contribution can be a gift if it does not comply with the election code. So there is an initial determination and adjudication that needs to be made before the board has subject matter jurisdiction to consider complainant's arguments under 2-130D1 and D2, the gift sections that are implicated in the complaint. State law vests the Secretary of State and State Ethics Commission with the sole jurisdiction to determine whether or not a contribution, including the one made by Ms. Alarid, complies with the election code. The election code is a creature of state law. This board is a creature of local ordinance. This board does not have the jurisdiction to adjudicate or enter any finding of fact or conclusion of law that Ms. Biscotti committed any violation of the election code. Thus, this board simply does not have before it the question right for review. The reason we're here is because the complainant has failed to exhaust their administrative remedies. The clear and proper course here would have been for the complainant to bring their complaint to the Secretary of State under the Campaign Practices Act. The Secretary of State and Ethics Commission would have done their investigation and entered a finding. And that finding would be whether or not Ms. Alarid's contribution violates the election code. The complainant has skipped that process of administrative exhaustion and wants this board to act basically as a super forum that has jurisdiction alongside the Secretary of State and Ethics Commission, but it clearly does not. The harm that will present to my client if this board exerts subject matter's jurisdiction to decide a question of whether or not a contribution violates the election code, again, a question that state law vests solely with the Secretary of State and the State Ethics Commission, we may have a situation, Mr. Chairman, where you have competing and contradictory judgments. So, for example, just thinking, hypothetically, if this board continues and asserts subject matter jurisdiction over this question of whether or not Ms. Alarid's contribution violated the state election code, it could be a situation where this board comes to one conclusion and the Secretary of State and State Ethics Commission later on comes to a very different conclusion. And that risk of contradictory judgments by two different forums is, Your Honor and Mr. Chairman, reason enough that this board should stay within its lane and should defer at the very least ruling on the allegations that Ms. Biscotti violated 2-130 D1 and D2 until the proper state entity, Secretary of State and Ethics Commission, which has jurisdiction, has actually entered a decision of whether or not Ms. Alarid's contributions violated the election code. That does not preclude this board from considering the other allegation that complainant has made, which is that Ms. Biscotti accepted a contribution of greater than $1,000 from a restricted person in violation of 2-130H2. That would still be adjudicable today. But in terms of the claims for 2-130D1 and 2, we would ask that those be dismissed or at the very least deferred for lack of subject matter jurisdiction. And complainant should then be required to exhaust their administrative remedies before trying to skip the process and bring the issue here today. Thank you.
Ms. Berger, would you like to, I'd like to give you a few minutes also, but can you also state your name and who you're representing also for the record?
Sure, thank you. Sarah Berger on behalf of the complainant, Carl Peterson. This is a lot more simple than Mr. Candelaria is making it out to be. He's also raising new issues that were not in his brief, so I would request that the board look at the pleadings, which we were going going to do and rule on it. First of all, we're not asking you to make a determination that Commissioner Piscotti violated the Campaign Practices Act, Reporting Act. I've stated that in my brief. That is not why we're here. You don't have to make that finding. We're not asking you to. What you're trying to decide is whether at that time, candidate Piscotti accepted a contribution from a restricted donor. Was that contribution lawfully made? As I stated in my brief, you can decide whether that contribution exceeded the Bernalillo Code of Conduct. There's a maximum of $1,000. You don't have to look to the Secretary of State to say whether that contribution is lawfully made. If it was not lawfully made, or if it was not reported in accordance with the election code, it's also not exempted from the definition of gift. So you've got a factual determination. That's very easy. Was it reported? I need time to examine my witnesses to prove that to you. But secondly, did it exceed the limits of your own code that you are granted subject matter jurisdiction to enforce? All of this question of exhaustion of remedies, complaints to the Secretary of State really have no bearing on this matter that's before you. You are certainly charged with interpreting and applying the code of conduct. The code of conduct is what defines gifts and excessive contributions and restricted donors, and that's what we're asking you to do. Thank you.
Okay. Any questions from the board members? We have a motion, we have a second. No more discussion? Okay, all those in favor signify by saying aye. Aye.
Aye.
Any opposed, say nay. Motion carries. All right. So each party will have 5 minutes for your opening statement. If you hear the bell ring, that means you're at your 5 minutes. So complainant will start it. So please go ahead, sir. Yeah, sorry.
Mr. Chairman, I have one more pre-hearing matter I need to address, if you would entertain that at this time.
You have 2 minutes and only 2 minutes, sir.
Well, Mr. Chairman, I have to raise this because there's an issue. I don't understand exactly what issues we're going to be trying today. So in the notice of hearing, this board made very clear that the only allegations that will be heard and considered today are the allegations that my client violated 2-130D1, 2-130D2, and 2-130H2. In the statement of issues, complainant is trying to add additional issues into that. Specifically in the pre-hearing brief, issues G, H, and I, which are based upon a vote that my client took to appoint the vacancy for Senate District 26 and alleges an additional violation of the code that Ms. Piscotti tried to place undue pressure on county employees. Issues G, H, and I were not pled in the complaint. They were not addressed at the preliminary hearing, and they were not part of this board's pre-hearing notice. So I would ask for a direction from the board clarifying that the only issues we're going to be adjudicating today are the ones I listed and the ones that are in the pre-hearing notice, and that these additional issues raised by the complainant in their pre-hearing brief will not be heard or decided today because they've not been adjudicated in the proper process to get us to this point.
Mr. Candelaria, could you restate what was that you believe should not be heard? So,
Sure, it's just referring to complainant's pre-hearing brief. Mr. Chairman, it would be issues G as in good, H as in happy, and I as in iguana.
Thank you, sir. Does all the board members have the complaint? It's on the statement of issues. So, Mr. Candelaria and Ms. Berger, if you don't mind, I'm going to give the board a few minutes to pull it up and look at it.
And if I may, if you look at the complaint, those allegations are in there. They are in the relief requested, page 4 of the complaint.
And I'll note for the board that while those issues do appear in the complaint, we're not going to dispute that. They are not listed as disputed issues, which is a separate page in the complaint. Secondly, when the complaint was filed and sworn, all of the issues addressed in G, H, and I were hypothetical. There had been no vote or action
Yes,
taken.
Mr. Candelaria,
Thank
please,
you.
I asked to give the board a few minutes to pull it up. No more discussion on this till the board members can look at it. Thank you, sir.
Sorry, just responding. I didn't understand that I was to remain silent, but I will now. Thank you.
Thank you. Ms. Berger, just to be clear, please let's give us the board members a few seconds. So any questions from the board? Is there a motion to take G, H, and I out? Okay. Motion dies. So we'll go back to open the statements. Thank you, Mr.
Mr. Chairman, again, I'm going to register a strenuous objection on due process grounds. This board is basically allowing all issues to come in, even if they weren't in the complaint, even if they weren't subject to a due process review, a preliminary hearing. This is
Mr.
a
Candelaria, Mr. Candelaria, your objection is on the record. You have our statement on the record. If you disagree with us, then please take it to district court. We are moving forward now into the hearing.
I think this is fundamentally unfair, Mr. Chairman.
Mr. Candelaria, do you understand we are now moving on from this?
I do. I'm just noting that you're acting in an unfair fashion.
Okay, Ms. Berger, you have 5 minutes. If you hear the bell, please stop. We have time limits, so you're up. Thank you very much.
Thank you, Jared Doucette and members of the board. I will be much faster than 5 minutes. This is a very straightforward case despite arguments from respondent. Vanessa Allereid lobbies the commission on behalf of San Lena's developer. She is married to State Senator Maestas. On June 2nd, while Commissioner Piscotti was a candidate for election to the commission, she received from Ms. Allereid a political contribution valued at $5,000. That contribution was not timely reported to the Secretary of State. And despite receiving what the evidence will show was her largest campaign contribution from a restricted donor, which actually should be treated as a gift, but regardless of either, whether you treat it as a gift or an excessive campaign contribution, Commissioner Piscotti did not disclose any actual or potential conflict of interest when she voted to appoint her lobbyist's husband to the vacant Senate seat. My client, Mr. Peterson, is here today asking for you to make things right, to enforce the Bernalillo Code of Conduct. He asks that you assess appropriate penalties for violations of the code, and he asks that you make a finding that Commissioner Piscotti should have recused herself from that vote. On behalf of my client and myself, I thank you for your time and your thoughtful consideration of the facts that you're about to hear.
Thank you. Mr. Candelaria, you have 5 minutes, sir.
Thank you. I will state again my objections, and I'm very concerned about the process this board has followed this morning. But I'm hopeful that we will still be able to obtain some semblance of a fair hearing today based upon the evidence, because the evidence today will establish some undisputed facts. First of all, complainant will not be able to establish that Vanessa Alarid is a restricted donor for purposes of the Bernalillo County Code of Conduct. Complainant has introduced a report from the Secretary of State that Ms. Alarid allegedly filed, listing herself as a lobbyist for West Albuquerque land holdings. That report was filed, however, because Ms. Alarid is a lobbyist at the state legislative level for that client. There is no evidence that she is a lobbyist for that client before the county commission. And to the contrary, the evidence today will establish that prior to June 2nd, 2022, and then prior to July 7th, 2022, the date that my client first became aware of this in-kind contribution and made her report, Ms. Alarid had not once spoken with Commissioner Piscotti or sought official action on her part. So they will be unable to establish that Ms. Alarid is a restricted donor. With regards to the issue of the appointment to the Senate seat, again, this issue was not in your pre-hearing notice, and it's incredibly unfair. The board is proceeding to hear this issue when you in black and white told us what issues would be heard today, but have decided to simply grant the complainant a last-minute opportunity to amend their complaint over our objections. Nonetheless, the allegations that my client violated the code of conduct by casting a vote for my replacement in the state Senate are meritless. The Bernalillo County Code of Conduct defines conflict of interest very specifically. It states that a commissioner has a conflict of interest that must be disclosed, and they must recuse if two conditions are met. One, they have a personal financial interest in the decision, or a family member does. That is not the case here. My client had no financial interest, nor did any of her family have a financial interest in the appointment of the senator for Senate District 26. Nor will complainant be able to establish that my client had a, quote, substantial interest in the appointment of Senate District 26. The evidence will also establish that Mr. Maestas, who will be sworn in as a senator in 3 hours, though he is already the senator for the district upon action by the county commission, he has not made a single contribution to Ms. Piscotti. And the innuendo, supposition, and allegation here is, well, because Senator Maestas is married to Ms. Alarid, who months prior to a vacancy opening up in the Senate for that seat made a political contribution under the First Amendment, that somehow that creates a conflict of interest that required recusal. The plain language of the County Code of Conduct establishes that position is meritless. The other issue that we believe the evidence will establish, Mr. Chairman, is that Section 2-130D H2 regulates monetary contributions only. It does not address or restrict in-kind contributions that an individual may make, even a restricted donor may make to a candidate. The language of the code tells us that is the intent. Section 2-130H2 talks about a campaign contribution. In other sections of the code, specifically where it deals with commissioner dealings with contractors who have financial services contracts with the county, the code talks about contributions and, quote, any other things of value. So we know that when the code talks about campaign contributions, it's talking about a very specific thing that is distinct from anything else of value, AKA an in-kind contribution. So at the end of this hearing, we will ask you to conclude that because Ms. Alarid made no financial contribution to Ms. Piscotti, but rather made an in-kind contribution, that D-130H2 is not offended. The Bernalillo County Code of Conduct is ambiguous at best. It does not talk about in-kind contributions in the way the city code and state code does. And that ambiguity alone is a reason not to find a violation of 2-130H2. The last issue, Mr. Chairman, is this. The code also fails to identify what standard of evidence the complainant has to meet in order to prove their case. And we are asking you that the appropriate standard or burden to place on the complainant today is clear and convincing evidence. Why is that? The allegations by complainant against my client do not involve allegations of mere negligence. for which a preponderance of the evidence standard would be appropriate. The allegations are willful, intentional, wrongful conduct. In light of that allegation, a clear and convincing evidence standard would be appropriate. And when that standard applies to the facts of this case, the board will conclude that the allegations set forth in the complaint are speculative at best, that Ms. Allered is not a restricted donor for purposes of the code. The mere fact she lobbies the legislature does not mean she is a restricted donor for purposes of Bernalillo County. And will also establish that the $5,000 contribution made by Ms. Allered did not violate the state election code, which limits in-kind contributions to $5,000 per general and primary election cycle.
Mr. Candelaria, your time's up.
I literally was finished and saying thank you, Mr. Chairman.
Oh, I thank you very much, Mr. Candelaria. All right, we'll move to the complainant's case, but I want to go over some statements. So the complainant will have 1 hour to present their case in full and 5 minutes for closing argument. You're not required to use all the time allotted to you. Following the hearing, the board may elect to go into closed session. All testimony will be given under oath and will be subject to question of the opposing party. The New Mexico rules of evidence and rules of civil procedure will not apply. With respect to evidence, irrelevant, sorry, I've been really sick, immaterial, unreliable, or unduly repetitive evidence may be excluded. Hearsay may be omitted. Administrative notice must be taken upon request of the parties pursuant to the rules of administrative hearing in New Mexico. Parties objecting to the evidence shall be timely and brief, stated on the grounds of the objection. Ruling on the evidence objections may be addressed on the record at the time of the objection. So, Ms. Berger?
Yes, Chair, could I make a point of clarification? So I know I have 1 hour for my examination and respondent has 1 hour and 15 minutes. I would like to clarify that means that when I'm examining a witness, my hour is being allotted, and when we have the same witnesses, when he's cross-examining, that his time is being allotted, and vice versa when he presents his case.
Attorney?
I'm sorry, I missed the question.
I wanted a clarification of the time allotment and how it's going to be imposed against me.
I've been advised anytime either of the attorneys are speaking, it is counted towards your time.
Okay, thank you.
Complainant has 1 hour, respondent has 1 hour and 15 minutes.
Okay. And when I'm speaking, the clock is ticking.
Mr. Chair, may I make a motion to exclude, to invoke the rule that would exclude the presence of witnesses who are not testifying?
I thank you. I was going to raise that next.
Is there a second? Any discussion? Not hearing none. All those in favor signify by saying aye. Aye. Those opposed, say nay. Motion carries.
Can I,
Okay, so if there's nobody that's not a witness, please leave the room and we'll get you.
A reporter? Am I allowed to be here? The media?
Yes, of course.
Okay.
Anyone on Teams?
Hello, this is Attorney Jason Alarid here, appearing specially on behalf of Ms. Vanessa Allard, who will not be appearing today as having not been properly served in accordance with the rules. I was just observing for purposes of this hearing and also to inform the commission or the board of the problems with service specifically in this matter. I'm not sure if a return of service has been filed, but I would imagine either it has not been filed or necessary components of the return of service would be deficient, and further evidence of the failure of the complainant to properly serve Ms. Allard.
One minute.
Chair, may I have a moment to rest when you're ready?
Yes. That's fair. Go ahead, Ms. Warder.
First, all three witnesses that were served subpoenas were properly served by a process server who notarized and submitted to me returns of service that were then filed with the compliance office. So there is no defect with service, and I would like to state my objection that all three of these witnesses were compelled by the subpoena to appear here in person. Ms. Nix was here, and I object to, obviously, Ms. Alareed refusing to attend, and I certainly object to Commissioner Piscotti not attending in person. That affects a short amount of time. It affects my ability to share documents with them, to impeach them. And I think it's very prejudicial and a violation of your powers to issue subpoenas when they are just sort of ignored and flouted. But short of asking for a continuance, which I will reserve that right depending on how the testimony goes, but I feel like I may be unable to put on my case without both Ms. Alareed present and with Commissioner Piscotti remote, and I assume in her attorney's office. I said short of doing that, I would like some leeway on time, especially as it relates to having to share documents. I don't even know technologically how I can share a document with a witness who is remote. But I don't want to waste all of your time who did show up for this here. But I reserve that right if I can't put on my case without these witnesses present.
Okay, thank you. Mr. Alridge?
Yes, Your Honor. Basically, regardless of the notary is ineffective to, overcome the requirements of Rule 1-045 of the District Court Rules governing subpoenas. The return of service, however, does have certain, obviously things to be served by the, signed and filled out by the service of processor. And first and foremost, it has to be served upon a resident of the household. Secondly, it must follow the rules established in Rule 1-004E3 and also comply with the statutes section 10-8-4 A and 10-8-4D, and also Rule 1-005, specifically unless Ms. Alareed is a member of law enforcement or otherwise employed by the state, it should have been accompanied by a witness fee, but it was not served on anyone in the household. Instead, allegedly, it was served on a law enforcement officer not associated with the household, but on guard duty due to the recent threats against Ms. Alareed's husband, Mr. Maestas, and his family. And so that being stated, the service is not proper. Furthermore, I would emphasize that the issues of service in this case is also part and part to the complainant failing to request subpoenas of the court until the last day offered under the pretrial order, being January 3rd, noting that they were not issued just by virtue of what's online until I believe January 9th. And specifically, The returns of service have not been filed or at least uploaded as of today, so I can see them, or at least day before today. So that being said, there's been no compliance with the rules. The ability of the commission to enforce the rules needs to be based on the complainant following the law, and the law clearly was not complied with by the complainant, and it was done so both at the last hour and not complying with the rules. Thank you.
First, I'd like to make an objection that I don't know who Mr. Alareed, he has not, to my knowledge, entered an appearance in this matter. I don't think that it would be fair. I think it is prejudicial to my client to allow someone who was served, obviously received the subpoena, to make a last minute effort to avoid appearance by having someone who is not a party to this matter or an attorney for her or entered an appearance in this matter to make these arguments. So I think you should disregard those. You have the return of service. She is not here. And it is clear that they are not going to present her. And I, at this time, ask that the board have the county attorney issue subpoenas from district court, since all three, well, two of the witnesses, one had a conflict, I understand that, but none of them are here. And I'd like a court to issue new subpoenas and ask
Well,
for.
One second, please. Ms. Berger, I just want to make sure I understand what I'm hearing. I just want clear that you want us to reschedule.
Yes, and have actual subpoenas issued by the district court.
Okay. Mr. Candelaria, I'll give you a few minutes if you want to give your thoughts on this, sir.
Yeah, Judge, Your Honor, Mr. Chairman, I don't think a subpoena from district court is required for my client. She is appearing in a method that the notice of hearing for this hearing specifically permits, which is electronic virtual attendance. I also emailed Ms. Florence yesterday at 4 o'clock advising the board that we would be appearing virtually, and there was no issue. I got an email back confirming our attendance, everything's good, and hence why we're here in Google Meets. So the allegation that somehow the complainant is subject to prejudice because my client is with me in my office appearing by Microsoft Teams in a fashion approved by the board is simply meritless. Furthermore, Ms. Berger needs to follow the rules. From what I heard from Mr. Allered, who is an attorney entering his appearance in this forum on behalf of his client, the subpoena on Ms. Allered was not served on her personally or any member of her household, and there was no witness fee. If complainant wants everyone else to play by the rules, he should start by having his attorney play by the rules as well. So we would object to a continuance. I think that's prejudicial to Ms. Biscotti. If the complainant failed to follow the rules and notify witnesses and subpoena them appropriately, that's on them. I don't think they should get another bite at the apple. I spent all day yesterday preparing for this hearing. My client has the burden of this ongoing politically motivated, meritless charge against her. We're here because Ms. Berger didn't follow the rules. I don't think they should get leeway.
Mr. Candelaria, you've made your point.
Mr. Chairman, can you just tell me how much time I have? Because I feel like Ms. Berger can go on as long as she wants, but anytime I open my mouth, you cut me off. I just want to know how much, maybe in the future, tell me that I have 10 seconds and I'll stick to 10 seconds. Thanks.
Mr. Candelaria, that's a valid point, and I will do that, sir. So I'd like to make a motion that the board goes in closed session. There's a second. Any discussion? Oh. Sorry, I'm learning too. So read the statement. All right, motion to close the session for the purpose of deliberation in connection with administrative proceeding held by the public for the discussion of the matter of Peterson versus Biscotti pursuant to 10-15-1 H-3. All right. So moved. All those favor? Oh, need a roll call vote. Thank you. District 1?
Present.
No, yes,
Yes.
yes, thank you. District 2?
Yes.
District 3?
Yes.
District 4, yes. District 5?
Yes.
All right, we'll go in closed session. Everyone, if you could please leave. You can go off there. Thank you.
Excuse me, Chair.
Yes.
We had the room reserved for conference.
Okay, we'll leave. Everyone can stay.
This makes it.
Ms. Florence or anyone, are we gonna be videoed into this other room where the board is going? I guess we're gonna have a hearing without us even present.
Jacob, this is Sarah. It's a closed session. We're not allowed in it. It's a closed session of the board.
This is a meeting minute.
Oh, certainly. His name Benson. That's MERPI.
Are you with me?
No, I'm just a member of the public.
Okay. Oh, thank you, Seth. I'm sorry.
Did you never got the email? I thought I did my yours.
So now, like, I'm considered spam.
Well, and I go to junk mail because I do. I have
Yeah.
to check junk.
Yeah.
Do I have a card?
Oh,
Because if you need
I
electronic.
mean, I have my
maybe-
business.
For some reason, all these
Okay.
are sent
I mean,
to me
you're-
that
you're-
it's better
I'm a reporter,
Okay, with.
the Albuquerque Journal.
Excellent.
Yeah.
And so I searched and I said,
Thank you very much. So how long? I mean, I don't know.
Rachel, can you let the parties know here in the next minute or so that we're just waiting?
On behalf of the board members, they will reconvene in the next couple minutes. Thank you.
Ready? We're ready? All right, let's go back on the record. Let the minutes reflect that the matters discussed in the closed meeting were limited only to those specified in the motion for closure and no actions were taken. The closed litigation. Okay, is there a motion?
Mr. Chair, I move that the board issue a new meeting agenda and a new notice of hearing for the evidentiary hearing in Carl Peterson versus Commissioner Charlene Piscotti, link 2022-001, to occur before February 8th in view of the challenge to the subpoena by Ms. Allery through her counsel, and that the agenda and notice specifically state that all issues pleaded on the face of the complaint will be heard.
Okay, is there a second?
Second.
Any discussion with the board members? Hearing none, all those in favor signify by saying aye.
Aye.
All those opposed say nay. Motion carries.
Mr. Chair, I also move that the board request the county attorney pursuant to Code of Conduct, Section 3BG, to issue subpoenas for appearance in person of all witnesses and parties at the evidentiary hearing.
Is there a second?
Second.
Any discussions? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed, say no. Motion carries. Motion. We're done. Motion to adjourn. Is there a second?
Before we adjourn, I have a question for counsel, for parties and witnesses. Mr. Candelaria, Mr. Alarid, are you willing to accept service on behalf of your client in this matter?
Well, I'll address that. My office already did accept a subpoena. I think it's unnecessary for another subpoena to issue for my client. Lastly, and I know, Mr. Chairman, you'll probably stop me from speaking in a moment, but I do think it's important to notify the board that my office will be filing for a temporary restraining order and declaratory judgment action to stay these proceedings due to the fact that the board has, in our view, exceeded its statutory mandate and exerted subject matter jurisdiction in a way that violates my client's due process rights. So we expect to serve the board with the TRO early next week.
Thank you, sir.
Thank you, Mr. Candelaria.
I would need to consult with my client regarding acceptance of service, but for right now, she would just need to be properly served.
Any other questions by the board member? All right, we're adjourned. That was a fun time.